Hello, students. This is Dr. Martin. This is the last of the series of lecture materials that you'll be receiving this particular semester. I just want to make sure that we had a chance to go over a bit some material on the courts and the legal system that we hadn't managed to get to yet as we were working our way through the three branches. This will be, I think, pretty easy to understand, and I think I am not actually giving you a particular assignment associated with these notes. The way this is going to work ideally, these are notes that hopefully will help you when you're preparing for your test next week, which once again will be online. But I'm not going to have any necessary homework straight up required. However, I am going to be on Friday holding basically all office hours via Zoom. And so, pretty much from locally here in Iowa, 9 in the morning to about 4 in the afternoon. I can go further than that if required. But pretty much anything and everything you would like to ask, you have all day to do it, and I'll happily answer all your course related questions in terms of the subject matter of what's going to be on the final test. So, if this is something which you would like to engage a little bit more with the material, or just to clarify anything that isn't clear already that comes out of your notes here today, please go ahead and let me know as soon as you can, and I will try and accommodate you as soon as possible. So, moving into, let's just kind of go through some of this material as it appears on your study guide, because I think in some ways that's probably the easiest. The first two talk about the common law tradition and the concept of stare decisis. These are actually two interrelated concepts that I think, if you look at comparative legal studies, this particular idea, in opposition to what many European countries do, is what makes the United States and the UK's legal system distinctive. In many cases in Europe, you have a very administrative and top down kind of legal system in terms of application of the law. That's something they inherited from Napoleon. Whereas in the case of the UK and the United States, a lot of this is much more evolutionary, which is to say, based on precedent, case by case, one at a time, either confirming what someone else has said before or coming up with a new variation on it. So basically, common law in that sense is pretty much how the legal system in the English speaking world has evolved over the last 500 plus years. Now, however, what that also means is that there is kind of a default setting for when cases come into court in English speaking countries and courts where that's the particular method, which is to say stare decisis. Stare decisis, if you don't understand the Latin, it is not stare decisively. More to the point, it is let the decision stand. Let the decision stand in terms of if the precedent that is controlling a certain case, which is to say, a decision that was made, say Roe versus Wade, many years ago, is the standard under which a current case about abortion is being contested, then as often as not, leave the precedent in place. If it's not broke, don't fix it. And so, generally speaking, you're going to see a preference for the likes of stare decisis when it comes to how cases get applied. So that's a little bit of a distinctive mark of UK US legal system that's important to know when we start getting into what makes for an activist judge. In other words, someone who takes a very aggressive view of how the interpretation of the law should change, and those who think it should stay relatively the same. Now, there's a couple of other principles that are going to be particularly important when you understand how it is the court system works. One of those is, for a mouthful, counter-majoritarianism. I think that's fairly easy to understand insofar as you're talking about what needs to be projected against the majority. Excuse me, what needs to be protected from the majority. And in that case, I think the answer is, of course, minorities and their rights. It would be easy in a democracy for, if you did not have these protections, a majority to come up with particular policies which oppress the rights of a certain minority. And that could be any ranging from race to religion to gender, does not matter. But therefore, the will of the majority may need to be checked by the fundamental rights that you're familiar with in the Bill of Rights, but also making sure that they are applied and applied correctly through the court system. So counter-majoritarianism is the basic understanding that it is the rule of law, not necessarily just democracy, which is going to count in this branch of government. Let's talk a little bit about where the action happens in the court system. If you're going to look at which courts in the country are going to see the vast majority of legal cases by comparison with the federal court system versus the state courts and even the local and county courts, the answer is going to be very much on the state and local courts. Much of what the federal government sees is dwarfed by the amount of cases that pass through those channels. And there are good reasons for that. Now, to a certain extent, that also is going to be influencing what exactly happens to a lot of the suits that try and come through. Despite what a lot of TV shows might have you believe, majority of civil suits, either in the government at the federal level or the state and local level, are not going to make it to court. And that's overwhelmingly due, of course, to settlements outside of court, or mediation or arbitration. So just because you have quite a bit of business passing through the legal system, that doesn't necessarily mean that you're actually going to see things taken to trial. As a matter of fact, in many cases, you probably don't need to or want to. Now, whether you're going to be at the federal level or even the state and local level, there's a similar principle that applies for what it is the court actually does. And that principle, of course, is judicial review. Now, this is something that's a little bit of the kind of history homework that you probably had to do in high school, but just to briefly review, this is something that in the United States federal legal system you're going to see arising from a Supreme Court case called Marbury versus Madison. To make it fairly simple, this was the product of a changeover in power between parties for the first time in this country's history. And it was really a contest of a last series of judicial nominations and appointments made by the outgoing president, in this case John Adams, which were not going to be honored by the incoming president, Thomas Jefferson. And one of the people who had been appointed to that judgeship wanted his job, and being denied by the new president, sued to make sure he got it. That was our friend Marbury. He sued, arguing that he should have received it, and this went before one of the first big cases in the Supreme Court under Chief Justice Marshall. What they affirmed was that, yes, this is the appropriate venue in which to actually bring this, but it's not the one that is appropriate for the action that Marbury actually wants, which is to give him his court decision that would give him his job. He needed to go through a different court path to do so. However, in the process of giving that kind of decision favorable to Thomas Jefferson, he also laid out a particular kind of enunciation of judicial review, which is to say an expansion on what the Constitution implies, that the Supreme Court, the federal legal system, is a co-equal branch with the right to review law made by the federal government, to apply it and compare it against the Constitution, and where necessary declare it unconstitutional. This was not necessarily a consensus at the time, and therefore Marbury versus Madison was a place where that was established for the first time. And since then, that has influenced all subsequent legal institutions in the United States, particularly at the federal level, but the broad way that the principle is applied, you can also see at state and local court levels as well. Now, to a certain extent, therefore, what kind of cases is the legal system of the federal government going to review? And there are a variety of ones. One particular pathway is a dispute between states. We talked in the early parts of the course about what it was that the federal government needed to do to mediate between states and their disputes, particularly when it came to trade and flows of economic activity. And there was no place to come together to decide those questions. Therefore, the Constitution states that where there is a case like that, where the two states, one or another, are the plaintiff and defendant, it goes directly to the Supreme Court to be heard. However, many are also going to be applied to the Supreme Court, and these are the ones that you're often hearing more of, the court of last resort, passing through the different levels of the federal court system, and that's going to include district, appellate, and then the Supreme Court itself. When it comes to how that works, it's very much like a sieve, which is to say a sorting out. You have the vast majority of cases dealt with on the district court level. There are over 90 district courts across the country for the federal system, and most decisions in those courts will stay there. However, they can be appealed. The decisions can be appealed for various reasons. Something that they feel was not covered, misconduct or improper argument on the part of the prosecution. But ultimately, each of these has to have something that is disputable about it before they can petition going all the way to the Supreme Court as the last court to which they can actually get their case heard. And so what that means is basically less than 10% of any Supreme Court cases that actually get to them are they actually going to consider and take. So it's a very much a kind of funnel of less and less of the worthiest cases from their point of view are actually going to be heard. Now, to a certain extent, that's also going to have some serious effects given by the kind of justices that are appointed. Given that you have so few cases comparatively and the kind of influence they wield, there's a lot of attention that's going to be paid to who actually gets to be a justice on the federal Supreme Court. Now, you probably have seen many of the names of justices in the past. Sandra Day O'Connor for my generation, Ruth Bader Ginsburg, or the so-called notorious RBG for the kind of internet generation. But generally speaking, their stories are very heavily scrutinized these days. That doesn't necessarily just have to do because of wanting to be clear about their qualifications, but also it's especially the case about how they will rule on major issues. And that's particularly the case in hot button issues like, say, abortion. And so, therefore, everything and anything they've ever written, legally or otherwise, about a subject is going to be subject to scrutiny about what, in fact, it is they think and what, in fact, it is they might rule on and how. So, therefore, who actually is going to be nominated and what role they're going to play, much less can they get confirmed, will have a lot of consequences down the road. One saying about the federal government, personnel is policy. If you have the people who agree with you in the right positions, then that's how you succeed. And in no instance is that clearer than in the federal court system.